Hello, good afternoon or good morning, everyone. I'm Aaron Parry. I'm an attorney here at Mac Murray and Shuster, and welcome to our Privacy Watch Mid-Year 2026. If you have to drop off at any point or want to come back to this material later, there will be a recording available in about a week on our website. We'll send that out in an email as well. Feel free to share or use it later. There is a question box that you can use to post any questions that come up as we go along. We will try to hit those as they come up or near the end if time permits. We did get a lot of questions ahead of the webinar, so we'll try to work those in as well. Unfortunately, Josh had a last minute illness, so for all of our big Josh fans, including myself, unfortunately, he will not be able to make it on this presentation, and that leaves Rhinestone Aaron to take the place of Diamond Josh as well. Nonetheless, we have a lot of good stuff to cover and good information to pass along. As always, we have to give our standard legal disclaimer. Nothing in this presentation is legal advice. Consult us or your own attorney. So jumping right in, the state privacy landscape has been eventful in 2026. Some 23 states have considered over 50 privacy bills, and many of those are new comprehensive privacy laws. A lot of the states with laws already on the books have begun to amend their privacy laws. And we'll take a look at all of those, but the new state laws and the amendments to existing laws. All this being said, there's still no federal privacy law. There have been a few bills introduced this federal legislative session. Most notably is the Secure Data Act that was recently introduced a few months ago. That law or that bill has familiar thresholds just a bit higher than what our state privacy laws have. It's a 200,000 consumer control or processing standard and a $25 million annual revenue, or 100,000 consumer collection process threshold and 25% of annual revenue from selling personal information. So mirrors our state privacy laws a bit, but is actually a little bit more of a heightened standard. There is no private right of action under the federal bill, and it would preempt state laws. Those last two things, the private right of action and preemption, is the big debate at the federal level. That it's what splits the aisle. The left side of the aisle wants a private right of action and does not want a federal law to preempt state laws like California's CCPA or CPRA. While the right side of the aisle does not want a private right of action and does want preemption. What this bill does shift more to the right side. So we will see how this plays out. Honestly, I do not expect this bill to pass in the near term. The primary barriers that have blocked a federal privacy law are still a challenge, and I just don't see that this is going to pass in the near term. Whole lot of AI regulation going on too. Probably over 20 bills that have state bills that have been signed into law governing some aspect of AI. Some of those are more comprehensive. Some of those are limited to specific industries or topics. But probably the three most common types of these AI bills are governed companion chatbots, employment, use of AI to make employment decisions, and then governing large frontier AI developers, the open AIs and the Googles of the world, not necessarily a deployer of one of those AI tools. A few noteworthy AI bills AI bills that became law before we jump into our privacy angle. Colorado passed a bill to amend their comprehensive AI law that applied to both developers and deployers of AI systems. It specifically addressed or more thoroughly addressed developers and deployers of AI systems that make or substantially assist in making a significant decision related to lending, education, employment, etc. That Colorado faced a lot of pressure from the federal government to constrain their AI bill a little bit, and they did just that. The Connecticut Senate Bill 189 that was passed a couple months ago waters down that comprehensive AI law. Mostly applies to developers, but does carry over some significant deployer obligations too. Connecticut also passed Senate Bill 5 recently, and it was a pretty wide-ranging AI bill that governed companion chatbots. In a companion chatbot, just to be clear, that's not it's a more expansive AI chatbot than our regular, customer service chatbot or something that we might access online to, ask what a return policy is or something. These are chatbots that maintain an ongoing relationship with us. It can elicit emotional responses. It's a chatbot that it kind of acts as a friend or a mentor or guide or something like that. So not our average just our consumer or customer service chatbot. The Connecticut bill also addresses automated employment decisions. That's been a area that we've seen a lot of AI regulation target, and that's using AI to make decisions about hiring, promoting, firing. So it really touches all aspects of the employment journey. And then it also governs the use of generative AI systems, but it's not it's pretty narrow for those rules that apply to the generative AI systems. So lots going on overall. There is never a dull moment. Every day whether it's a new bill that's become a law or whether there's a new enforcement action that's been released, lots going on, lots to stay on top of. So we'll focus now on our state privacy laws. We have 19 laws in effect today. You'll see that on your map as the states highlighted in green. There has been 4 new privacy laws passed in 2026, bringing our total to 23. So just under half of the U.S. states now have a privacy law on the books. You'll see the few states, the Vermont, Oklahoma, Louisiana, and Alabama, different colors there, and they have those colors denote different effective dates, which we'll take a look at here more in detail. So here's our new 4 state privacy laws. And as you can see, the thresholds generally mirror what we're used to. So if you are using a legacy threshold review, generally all right, but there are some nuances to account for. You can see there that Vermont has a specific threshold that is that only Connecticut has one similar, and Vermont's law applies if you control or process the sensitive personal information of 3,000 or more Connecticut consumers, or sell personal information of 3,000 or more Connecticut consumers. Vermont becomes the second state to have a revenue threshold that's directly tied to a specific type of personal information, sensitive personal information being that specific type, or for just selling personal information without having an attachment to a specific percentage of revenue derived from sales or sharing. Connecticut recently, Connecticut amended their privacy law in 2025 to add in even broader applicability thresholds. So starting on July 1st of 2026, Connecticut's privacy law will apply to any business that collects the sensitive personal information of Connecticut consumers or sells any personal information of Connecticut consumers. So Vermont kind of borrowed from what Connecticut did last year. Generally speaking, the four new laws mirror our existing patchwork. Familiar purpose use limitations, consumer privacy rights, requirements for collecting and disclosing sensitive personal information, data protection assessments, service provider contracts. So not a tremendous amount of nuance, but there is certain little things that go above and beyond what the patchwork otherwise has. Vermont, out of the four, Vermont is probably the state with the most onerous privacy law. It includes a specific application to consumer health data, and there's rules for any business that's collecting that type of consumer health data, and there is no applicability threshold for those consumer health data rules. So the thresholds on our screen here for Vermont are out the door. If you are collecting consumer health data, there's that section applies to you regardless of these applicability thresholds. Vermont also has offers consumers the right to obtain a list of third parties to whom personal information is disclosed. They become the fourth state to do that. Connecticut, Minnesota, and Oregon are the other three that currently have currently offer consumers a right like that. Vermont also includes the right to question profiling results for profiling for legally or significantly similar effects. So once again, that we're using AI or some type of automated processing for financial decisions, education decisions, employment decisions, access to essential goods, then we'll now have to offer a right to question that type of profiling, and only Minnesota and Connecticut have similar rights, and then Colorado and California have the most onerous or most robust rights related to profiling for legal or similarly significant effects. So now that we're up to 23, we've also seen a lot of states with the privacy laws already on the books that have begun to amend their privacy laws to tighten things up. And kind of, I'd say that the few biggest trends I've seen are certain bans on collecting or selling specific types of information. A popular one has been banning the sales of precise geolocation information. We've seen a few states do that in the past. We have a couple states that did it this year as well. And then several states have targeted specific industries. For example, Kentucky prohibits will prohibit the collection of automatic content recognition data. That seems to apply to video or video streaming providers that collect information about what we're streaming and watching. And then Utah has added several provisions to their privacy law that directly regulate motor vehicle manufacturers, and they broadened the applicability of their comprehensive privacy law to include motor vehicle manufacturers, even if there's some other exemption that would otherwise have applied earlier. The two most comprehensive revisions came out of Maryland and Connecticut, but generally they align with the trends we're seeing in other states. For example, Maryland has a ban on selling personal information to a government entity that engages in immigration enforcement. Connecticut, it bans the sale of precise geolocation information. Connecticut also had added in a data broker registration law. And just to recall, a data broker is generally defined as a business that buys and sells or mainly sells personal information of a consumer that they do not have a direct relationship with. So we've obtained this information from some place other than the consumer, and then now we're repackaging it, selling it downward. And we might collect that information from a publicly available source, from another third party. However that collection occurs, if it's not directly from the consumer, and then we don't have a direct relationship with that consumer, later on sell it, that's the type of action that would meet the definition of a data broker. And their law mirrors California's Delete Act. By creating a deletion mechanism similar to like think of the federal do not call list. This mechanism will allow consumers to sign up to say, I want you to delete my personal information. Data brokers are required to access that mechanism every 45 days and scrub and delete that consumer's personal information out of their systems, and to pass that request on to service providers who may process that data on our behalf, or to third parties to whom we've otherwise disclosed the data. In California, we are approaching the compliance deadline to start scrubbing their delete mechanism, or their drop mechanism is what they call it. That begins August 1st of this year. And the regulations are pretty specific on how that access and scrubbing and deletion has to occur. There's some pretty technical language in the regulations related to hashing the data that comes from the drop mechanism, and then using that to match up to the data that we have on file. And Connecticut's law mirrors the California law with respect to that in many ways. So overall, lots going on with the states that already had privacy laws on the books. Now they're going back and doing some fine tuning, strengthening certain provisions. So now is the time to revisit compliance plans and procedures to account for these updated laws, and then to start preparing for the effective dates of our 4 new privacy laws, which as I mentioned are significantly similar to our laws already on the books, just a few minor nuances to work with there. We're in a very interesting time. We're in this period where we're still seeing states pass new laws, seeing states amend their laws. Some states are just in the early implementation phase. Some states, California, Colorado, are well have implemented their laws already now and are focused on enforcement. And the enforcement is real. I mean, it's weekly now that we're seeing a state or federal action that's related to privacy. Probably the 5 main areas that we're seeing being policed are lack of valid consent, or the use of dark patterns to collect personal information. Remember, in some states there is a consent requirement to collect certain types of information, specifically sensitive personal information. Another big area is unauthorized data disclosures or data sales, where we're either selling, where these companies have sold the personal information or otherwise disclosed it without proper consent for those states that may require consent to sell personal information. Failure to honor consumer privacy requests has been a continuing enforcement priority for both federal and state regulators. And that is mostly tied to opt-out request, opting out of sales or sharing or profiling. And then also largely includes failing to implement a system to honor GPC signals or other web or browser-based signals that clearly communicate the user's desire not to have their personal information sold or shared. So that the failure to honor the consumer request is a recurring theme that we've seen since the first few privacy enforcement actions. Seems like every other one deals with failing to honor privacy requests. Another one is misleading or incomplete privacy disclosures. A lot of that has to do with our privacy policy not having not meeting the enumerated requirements in privacy laws. You know, if we're thinking about our whole patchwork, the list of privacy policy disclosures is about up to 70 different disclosures that all of the laws combined require. So there's a lot to sift through there just in our privacy policy alone. But then there's other disclosures, notice of ability to opt out of sales, targeted advertising, profiling. If we're offering a loyalty program or a financial incentive program tied to personal information collection, there's additional disclosures required there. my general sense on this is the low hanging fruit that regulators can easily view to determine if a business is in compliance with privacy policy disclosure requirements. So if you take away anything from this this part of our presentation, button up privacy policy disclosures. That's the easiest thing that regulators can see to determine how a business is approaching privacy compliance. Lastly, still seeing a lot of data security failures. Maybe not so much under our comprehensive privacy law umbrella, but maybe our data breach notification laws or other laws that require a more formal information security program. There's several states that, for example, require financial institutions to have a written information security program, and those tend to be kind of the big actions in terms of data security violations. So as we round out our privacy, our state privacy section here, the 6 things I'd leave you with is to just stay on top of what's going on, whether that's subscribing to our blogs, following folks on LinkedIn, doing a weekly check-in on your favorite sites, whatever way or method you have to stay abreast of all these changes is super important at this period, because there's just so much going on that it's hard to stay afloat with a reactive posture. 2025 was a bit of a godsend. Thinking back, last year there was relatively modest privacy updates. No comprehensive privacy law passed last year. We kind of got excited for our clients, thinking, okay, maybe this is the new normal. Maybe we won't see a whole lot of action after these states get the implementation done. Not the case. 2025 versus 2026, much different scenario. And I expect that in the future, it'll mirror 2026. A lot of activity, lots going on. Second, honor consumer opt-out requests. I just pointed out that that's been a major enforcement priority. But this really requires a deep dive to understand how both our process and procedure for honoring opt-out requests. A common issue that we help our clients work through is how to ensure that a cookie management tool interacts or responds to an online form submission or another submission method. How we can ensure that if a consumer tells us that they want to opt out of sales, on our online form, how can we ensure that our cookie banner gathers that information and turns off advertising or other cookies that may constitute a third-party sale. Third is audit our data sharing practices and vendor relationships. Now is a good time to map out our disclosures to really understand where personal information is going. Sometimes this gets lost in the shuffle. Fairly often when we go to work with a new client, that they are stunned about what types of data sharing was going on that they really didn't have a full grasp on. So now would be a great time to take a look back at our flows and ensure that we know exactly where personal information is going and why it's going there. Along with those same lines, our vendor relationships. We know that our state privacy laws have contractual provisions that have to be in our contracts with our service providers and third parties in California. Vendor due diligence and oversight is a huge priority for regulators. That they want businesses to ensure that they have some ability to understand fully how a service provider or vendor is going to be using personal information on their behalf, and then to remedy any type disclosures or uses of that personal information that is outside of the what's allowed in the contract. So you know, in a previous FTC enforcement webinar, some of our attorneys discussed just how much the FTC has really focused on vendor management and due diligence, and I think we'll start to see that flow over into our privacy laws much more. Review sensitive data collection and disclosure practices. We saw a lot of amendments to privacy laws surrounding sensitive personal information. A lot of states are tightening up their rules on collecting and disclosing sensitive personal information, and you know, for good reason. That's the sensitive personal information is that more intimate information that deserves stronger protection, and states are starting to ensure that their laws adequately protect sensitive personal information. Register as a data broker if required. We now have 6 states that have a data broker rule on the books. Out of those 6 states, 5 of them have a registration requirement. California is, of course, the most widely known because they have that delete or drop mechanism that the data brokers have to scrub. But there are 4 other states, Texas, Oregon, Vermont, and now Connecticut, that will have a registration, or that do have a registration requirement. Connecticut will have one from their recent amendment. Lastly, strengthen data breach response readiness. I think this gets overlooked. We focus a lot on securing our data, but not necessarily have a plan in place to swiftly act when we are aware of an unauthorized use or breach of that data. So continue working on our physical, administrative, technical safeguards to protect the data, but we also want to now look a step further and say, okay, if something does go south, we do experience a data breach, we're confident that we have a good process and procedure in place to quickly comply with our legal obligations, which typically require notice to certain parties, the affected individual, maybe a state regulator, sometimes a credit reporting agency. State laws vary on what obligations a business has to take once they become aware of a breach. So getting a policy now in place will save a lot of headache down the road. If an unfortunate breach would occur, it will save a lot of dumpster fires down the road. So switching gears here now to our state telemarketing amendments. Not a whole lot on the books thus far this year. We're really only looking at two amendments out of Tennessee and Utah. Starting next month in Tennessee, if you use an automated system to make pre-recorded or AI calls, you have to keep records of those calls, make semi-annual reports to the Tennessee regulators, and then cap those types of calls at 10,000 per month. Now, on its face, if you're a business that's making these pre-recorded or AI calls using an automated telephone dialing system, this law or this new law looks pretty onerous and pretty scary. However, digging deeper into it, the operative definition of the telephone solicitation excludes calls made with prior express written consent and excludes informational calls. So if we remember right, at the federal level, we already need prior express written consent to make pre-recorded telemarketing calls. Prior express written consent, a higher standard than the prior express consent that's already exempted from the telephone solicitation definition under Tennessee law. So if we're complying with federal law in the first place, this Tennessee rule is not applicable to us. We're outside of telephone solicitation definition. There's only a sliver of calls that may implicate this Tennessee law, even if we're otherwise complying with federal law. And I'm thinking our charitable solicitation calls, charitable contribution calls. So very narrow applicability if we are complying with federal law. One interesting thing that the Tennessee amendment does not define what an automated telephone dialing system is. If we're using the federal definition, that's a very narrow definition. If we're reading it a bit more broadly, that may be more closely aligned to our automated system for the selection and or dialing of telephone numbers. Point there being, it's worth it if you are using some type of an automated system to talk with your counsel to see if that system is the type of automated telephone dialing system that would make you have to worry about this amendment. Utah also had a kind of a broad update to their telemarketing law through an omnibus bill. It was kind of, I don't want to say snuck in there, but essentially it was a few pages of a 150 plus page bill, so it kind of did get buried in there. Nonetheless, it amends telemarketing registration requirements. Remember, 33 or 32 states and DC have a telemarketing registration requirement before you make your first telemarketing call. Unless you are exempt, you have to register with the state in order to make that telemarketing call. Utah strengthens theirs a bit, and it really doesn't make it more onerous, I want to say, but it does add in additional information that has to be that a telemarketer has to present in their application to make telemarketing calls in Utah. Also requires some upfront introductory disclosures, and that would include legal name, telephone number, complete mailing address, and email address. Other states have similar types of requirements, but these do go above and beyond what federal law requires. So now's a good time to look at our disclosures to make sure that if we are not already giving that information out at the start of the call, that we do that in Utah. Because if we don't, and a sale results on that telephone call, the consumer can cancel that sale at any time. It's a statutory right to do so. So any type of refund policy would be out the door, and the consumer could cancel at any time. So avoid the headache now, include those disclosures up front, save you a lot of grief on the back end. There's the The amendment also addresses cancellation rights. I kind of talked about how if we don't give the upfront disclosures, a consumer can cancel. It beefed up those types of cancellation provisions, and it also increases civil penalties. It keeps the $2,500 per violation penalty, but adds additional $5,000 penalties for repeat violations. So not a whole lot going on in the state telemarketing landscape. Federal level, a little bit of a different story. The FCC has been super busy on several fronts. At the start of the year, the FCC delayed a portion of the revoke all rule under the TCPA. That revoke all rule was adopted back in 2024 and largely went into effect in April of 2025, save for the part of the rule that would require telemarketers to treat a revocation of consent in the marketing context as also a revocation of consent to non-marketing calls. And this has created a huge issue specifically for utilities and banks and businesses that have to have a way to communicate with consumers about just-in-time urgent issues like bank fraud or maybe a power outage or maybe you forgot to pay your monthly bill and there's a disconnect notice. Those entities are very concerned that these critical notifications that the consumers will opt out of these critical notifications unknowingly. So the FCC delayed this rule before that April 2025 effective date. And then earlier this year, they delayed it again till January 31st, 2027. And the FCC has indicated that they plan to deal with this rule further. I think that they will deal with it through their delete rulemaking and just delete it off the books. Actually, the proposal under that delete rulemaking is to delete all of the revocation of consent rules that were adopted back in 2024. In the meantime, and until we get that full deletion or that partial deletion for this portion of the rule, just remember that we have to honor opt-out requests through any reasonable method. There are certain buzzwords that automatically are considered a reasonable method. If you get a stop, quit, end, revoke, opt out, cancel, unsubscribe, those are per se reasonable means or responses to indicate an opt out. If you do get an opt out, using another word than that list I just named, you should still treat that as an opt-out unless there is a pretty high level of confusion about what it means. And I'm thinking like things like a middle finger emoji or something. That's right on the line, but if you're taking a conservative position, probably good to treat that as a type of an opt-out. So just try to think of variations of those words that I listed and emojis that might mean those words and add those to your list of words that you recognize as an opt-out. Consumers can also submit opt-outs through any other reasonable method where they can expect to reach the business. So that may come in on like a contact us page. They may call the sales number or a number that's not otherwise held up for opt-outs. Just know that if that occurs, we still have to treat that as a reasonable opt-out. And then we want to opt out those opt-outs as soon as possible, no later than 10 business days. Under the delete, that was kind of a call from the FCC asking what should we delete in our TCPA rules. There was a lot of topics on the chopping block, and we expect that the FCC will be proceeding in that rulemaking sooner than later, especially due to their earlier indication that they will act on that portion of the revoke all rule before the January 31st, 2027 deadline. A few rulemakings are in comment period or reply comment period now. Those relate to numbering resources, and then that includes pretty much all aspects of numbering, including access, acquisition, sale. So not a whole lot here for a good amount of telemarketers, but just something to pay attention to as this rulemaking goes on, because if you are using several numbers or rotating numbers, that may change based on this rulemaking. Lastly, the FCC is dealing with foreign call centers. A whole lot of proposals there. Is some related to English proficiency. If you're using an offshore call center, the agent in that call center has to be proficient in English. You have to give certain disclosures to the consumer. You have to offer them a right to speak with a U.S. agent. So be interesting to see where they land here. A lot of the comments in the rulemaking strongly oppose that type of regulation. So we'll see where the FCC lands on that. So hitting a few big federal telemarketing issues, hot items. In the past few years, we have seen the depowerment of agency regulation. First, in Loper Bright, we saw the rollback of Chevron deference. Before Loper Bright, courts had to give deference to agencies and follow an agency's reasonable interpretation of a federal statute. Loper Bright kicked out Chevron deference. Now federal courts do not have to follow an agency's interpretation of the statute. Soon thereafter, the Supreme Court also determined that federal district courts are not bound to a prior FCC interpretation of the TCPA during subsequent enforcement proceedings. So once again, kind of giving federal courts more power to determine if a violation occurred without having to consider what the agency might have said should occur. All this has resulted in courts interpreting the TCPA entirely different. In a few big cases, courts have held that prior express consent under the TCPA may be given orally or in writing. Remember, the TCPA, the federal statute, only uses a prior express consent standard. It doesn't use a prior express written consent standard. It was the FCC's regulations that added in a written consent standard because the courts deemed that addition of written by an agency was not a reasonable interpretation of the TCPA. Courts have said, we're not going to even pay any attention to the FCC's regulations. We're just going to say that, no, we're following the TCPA here. You don't need prior express written consent to make pre-recorded telemarketing calls. You don't need prior express written consent to use an ATDS. You only need prior express consent. And that case, one was in the Fifth Circuit, which includes Mississippi, Louisiana, Texas, and then the other was the District Court of Maryland. Now, that is, the what we should do right now is probably still follow the FCC rules. I mean, unless you are in a little area of Texas, only calling into that little area where you're fully protected by the recent Fifth Circuit decision, then maybe there's a reason to rely on that case. If you are outside of the Fifth Circuit of their District Court of Maryland, or if you're making calls to consumers all over the country, probably harder to segment that out, and so easier to just continue to apply the written consent standard. In the same breath, we're seeing courts wrangle with the question of whether text or telephone calls under the TCPA. Once again, the TCPA statutory text uses telephone call. It doesn't define that. FCC and FTC have interpreted telephone call to include text message, even though it's not in the federal statute. And now some courts, albeit the minority, are saying telephone call does not include text. Still, the majority view is that telephone calls do include text messages. So once again, at this juncture, it's the conservative and easier position is to continue to treat text as calls unless you are comfortable relying on a few of the minority cases that have held otherwise. Okay, I am having a tough time getting that back up and running, but nonetheless, we're nearing the end anyhow, and I'm getting close to the end, so I'll just proceed quickly without the slide. Not going to miss a whole lot. Plus, we'll have the slide available for the last 2 or 3 slides if you want to view those. But I'll kind of hit them hard here. So, all that being said, with our with all of our decisions involving consent, just know that courts are increasingly questioning agency rules that added consent requirements beyond what Congress had enacted. But the conservative compliance is to continue complying with those FCC consent rules, and to continue treating text as calls for DNC purposes. Just another thing, agency guidance is no longer a safe harbor. So if you're using a favorable agency decision, tread lightly, reconsider that position, because we're now seeing courts are paying smaller or littler attention to what agencies have said. Also remember that there are other rules, other federal rules. For example, the TSR that the FTC enforces has a written consent requirement for pre-recorded messages. Some state do not call laws may independently treat calls as text and may impose stricter requirements in federal law. So be sure to harmonize all the telemarketing rules if you are making a decision based on one of these cases. Last big thing I want to talk about was using arbitration as armor. We've talked about the ways that the telemarketing landscape is changing at the federal level. There's some business-friendly court cases, some consumer-friendly, but there is still an ability for a business to contain their liability, and strong arbitration provisions in a customer service contract will give you that ability. The M&S was happy to argue this case in front of the Eighth Circuit and secured a victory for our client. The key holding, though, is that arbitration that applies broadly to any dispute arising out of or relating to the party's agreement will survive the termination of that agreement. So if a subsequent text down the road related back or is connected to that prior relationship, that arbitration clause, even though the contract may not be effective anymore, would still apply. Good time to ensure that our customer service agreements have beefed up arbitration provisions. So to finalize our telemarketing area, my top three focus areas are transparency, disclosures, and substantiation. And this is really in the entire marketing context. Last year, in the telemarketing world, we saw the FTC take action against two lead generators for a variety of misleading practices, from lead collection clear up to call content. There was misleading aspects, and they got hammered pretty hardly for that. In other realms, like our negative option area, there is a huge focus on deceptive enrollment practices, inadequate disclosures, difficult cancellation procedures. So once again, even in our negative option world, we're focused heavily on transparency. In our email marketing world, we've seen a whole slew of increased litigation under certain state email marketing laws, specifically the Washington SEMA. That has been a huge plaintiff-friendly statute, and that's partially because a court last year had held that an email that contains any false or misleading information violates the SEMA, not just a material falsity or a material misleading information, any type. And what that caused was, for business, they might have sent an email out that says this sale ends today, and then later on in the evening they said, well, wait a minute, this sale is extended for 12 hours till tomorrow at noon. That had then caused them to get sued by a bunch of plaintiffs that said that was a falsity, and it's resulted in 200 plus lawsuits being filed under the law. But the Washington legislature did deal with the increased SEMA litigation by watering down the statute and lessening the amount of statutory damages available to consumers from $500 to $100. They added a knowledge-based, actual or implied knowledge-based standard instead of that more strict liability standard. However, the amendment does not apply retroactively, so any case that have been filed will proceed as normal. Anything after June 11th, 2026 will be subject to these knowledge standards and lower penalty provisions. So if we're doing email marketing, pay particular attention to sales expiration claims, limited time promotions, inventory and availability representations, discounted percentages and pricing, and then last chance, ends tonight, ends today, or urgency claims. Those are what's really driving email marketing lawsuits. So even though the Washington legislature narrowed the penalties under SEMA and made it a bit harder for plaintiffs to sue, we still want to focus on ensuring we're, that there is no way that someone could allege that our emails contain false or misleading information. My second is consent. We talked a lot throughout this presentation about when consent is required, how not secure obtaining the proper consent can land someone in a lot of a mess of trouble. So ensuring that we have a strong procedure to obtain the right consent, balancing federal and state rules, and then acting on that consent appropriately is super important. And what I mean by that is, if we are using a lead form that talks about health insurance, we're not using that lead to contact them about replacing their roof or something like that, something totally different from what the consumer consented to be contacted about. Lastly is opt-outs, and treating opt-outs or getting our opt-outs and honoring them as soon as possible. And I'm talking DNC, proper procedures to scrub against federal and state do not call registries, strong procedure to handle internal do not call requests. If we may have several entities making calls on our behalf, or maybe a part of a conglomerate that's making calls on someone's behalf. Ensuring ways to share that data and to gather all that into one area so that we can easily scrub against that's key. Consent revocation, we know that there's the rules are up in the air, but that consent revocation is a pressing issue, and we've seen a lot of increased litigation under the TCPA related to businesses that continue to contact consumers after they've opted out. So having a strong process to ensure that if a consumer opts out, that we respect that'll save us a lot of grief and a lot of headache. And then the reassigned number database, only Maine requires consumers to scrub against the reassigned number database. The TCPA takes more of a safe harbor approach. If you scrub the reassigned number database and then RMD tells you that the number has not been not been reassigned, and you call that number, that will operate as a get a jail free card and can save liability down the line. Sorry I went over, had a few technical difficulties, but nonetheless we proceeded. I was sad that Josh couldn't do this with me. He's a lot smarter, sounds better, looks better. But apologize that you got stuck with Rhinestone Aaron. Nonetheless, I hope that you found some value here. If you have any questions, you see my email right on the screen. And happy to answer any questions you have. Once again, recording will be available as well as the slides. So share this with your colleagues and take a look back to see if there's anything that you might want more information on. With that being said, really appreciate it. Thanks so much, and looking forward to seeing you all here soon and on our next webinar. Thanks a lot.